and my students, today we shall again see the POCSO Act 2012 and further in last class we have seen the chapter 5th in which recording of cases had been solved before you. Today we shall also discuss chapter 6 of this act, and in which there are at least 4 sections there. Section 24, 25, 26 and lastly it is section 27. All are related with the recording of a statement of a child, and so one by one we shall discuss the statement taken by police, magistrate and the documents and the report of the police are also taken by or given by the concerned authority like police officer or magistrate withal. So let us see chapter 6 on your board. Chapter 6 of POCSO Act 2012. Section 24, recording of a statement of a child. This is punchline or headline of section 24, which shows that the statement of a child, how it is taken, how it is made by the child, and so many protection and cares are taken by the authority who takes the statement of the child. Now, the recording of a statement of child, here it is a child that may be male or female, and in the case of female child, some protection, some care, some attentions are necessary, which is to be taken by the authority or police officer or the magistrate as the case may be. Now, first of all, what is the procedure of recording of a statement of a child? You can see here. In subsection 1 of the section 24 says that the recording of the statement is taken of a child according to the following ways. First, a child maybe a child may be at the time of statement shall be at his residence. Second, at the place of the choice of the choice of a child. This is very vital. At his residence means where he resides. And another clause is that at the place of the choice of a child, where he wants to give his statement, it depends on him that what he wants to do. Second, subsection second says that a police officer must be woman police officer. A police officer who is authorized to take the statement must be woman police officer, not less than मिटाने वाला less than or below the rank of sub inspector. Third is the police officer must not be in her uniform. These are very vital while the interrogation or a statement made by the police officer in this case. Now, next subsection says that at the time of taking a statement, the accused person must not be come in a cross with the with the child who is making such a statement. Now, fourth is, it is the duty of a police officer not to detain the child at night for any reason. Last, the duty or liability is also with the police officer not to disclose the identity of the child for any reason. These are the subsections of section 24, which are very vital with regard to the statement taken by the police or police officer. Now, second is recording of a statement of a child taken by the magistrate, section 25. Here is all about section 25. अरे कपड़े ठीक था, देर लगेगा. Now, section 25, recording of the statement of a child by the magistrate. This is all about your section 24. Subsection 1 says that a magistrate shall record the statement of a child under section 164 of CRPC. Here one should note the point that if the statement taken by police, it is not under judicial custody but it is under police custody. Whereas if a magistrate takes the statement of a child, it comes under judicial custody. This is the procedure of the court which has been given in or under the CRPC Act, which perhaps you have read or you want to see in detail, you can consult CRPC all about. Now, at the time of taking the statement of a child, there is no need of presence of an advocate of accused person. Now, it is said in subsection 2 that a copy of the report of police when investigation is over, be given to accused person or his relative or relatives or his parent or the person in whom the child has trust or confidence. This is very vital. And copy of any document in this regard is also available to accused under section 207 CRPC and under section 173 CRPC. This is all about the recording of a statement of a child by the magistrate. Now, section 26. Section 26. This is additional provisions for taking the statement of a child and so. This is the headline or punchline of section 26. Here the word additional provisions. What is the meaning? Meaning is that the statement taken by either police or magistrate, there are so many provisions has been given in the act, either POCSO act or CRPC or any act like child child right protection 2005. So these are the conditions, these are the provisions must be applied either by the police or the magistrate in additional provisions. Now suppose if a child is disabled, either he does not hear or he does not speak, then what would be the result of a statement taken by police or magistrate? In this regard, a magistrate or police can take the help of or assistance of the expert, like the educator, like the person who understands the language of the person who is disabled. And so, for this reason, some additional provisions have been made under section 26. And so, we should take the help of these sections. The statement taken by magistrate or the police may have the easy so that they can take the statement of the child in a smooth way. Let us see what are these. First of all, we can see the subsection 1 of section 26, that wherever necessary, the magistrate or police officer shall record the statement of what is actually spoken by the child. So, it is very vital to note it down. Not only this, the presence of his parent or the person in whom he has all trust or confidence. This is very vital in both cases, and the relative or the parents or other person of his choice, they are allowed to remain present at during the statement made by the child. Now, next point is that the magistrate or police officer may take the assistance of a translator, interpreter, or any expert who bears or bear the qualification and good educator, so that recording shall be made in good way. The person who is or are acting as an expert shall be paid the remuneration as prescribed by this act. Now subsection 3. The magistrate or police officer may take the assistance of the person who is or are expert in regard of a child who is by the way is disabled and not only this, the expert or assistant is or are qualified to understand the physical as well as mental disability of a child on payment of the fee prescribed by this act. This is all about your section 26 of subsection 3. Now, section 26 subsection 4. In this subsection, the magistrate or police officer shall ensure that the statement of a child have been made also in audio, video, electronic system. This is all about your section 26. Now, lastly, the section 27 is related with medical examination of a child. Now, in a general process, a medical examination is also held under the provisions of the sections in CRPC. Now, in that case, some general procedure is taken place, but in case of 164A, if a girl child is there, this is a new section imposed very recently, and it deals with the child already raped and there is a accusation of rapist. Now, in that case, if the girl child comes to the under the police officer or magistrate, whatever the case may be, the medical examination is done if or whether FIR or any complaint has not been lodged. In that case, a medical examination is performed by the medical hospital under the guidance of or under the lady doctor or medical officer who is female. Suppose that in case there is no medical officer available, in that situation, a head medical officer or medical doctor who is working in a medical institution may be taken the position of the head of the examination committee, and then examination of the girl child is taken place. Not only this, this is also happens sometime there is no presence of any relative or parents or person who is in whom the child has trust or confidence. In that case, the head of the institution is already given the authority under whose supervision the examination is performed.